This is part 9, and in this part, right in the beginning, we shall start discussing chapter 10 of the Negotiable Instrument Act of 1881, dealing with reasonable time. As a student of law, you must have come across this term, or you shall be coming across this term, which is reasonable time is a relative term. Now, from the point of view of Negotiable Instrument Act, we shall be making mention of this term every now and then. And hence, first of all, though there are many terms of which you are not aware at present, or with which I have not discussed, we shall be discussing. But then, when we will be coming across reasonable time, something is required to be done within a reasonable time. Naturally, as far as this enactment is concerned, you will have to refer to right from section 105 up to 107 of this enactment. Now, section 105, as far as this chapter is concerned, heading of the section is reasonable time. And what it says in determining what is a reasonable time, in determining what is a reasonable time for presentment for acceptance or presentment for payment, for giving notice of dishonor, and for noting, regard shall be had to the nature of the instrument and the usual course of dealing with respect to similar instruments, and in calculating such time, public holiday shall be excluded. So now, whenever it is necessary for us to understand as to provisions regarding presentment for acceptance, presentment for payment, giving notice of dishonor, and then what do you mean by noting, with which we shall? So these are the terms with which we should be familiar. So now today is the first, maybe the first time that you are, listening to all these terms. We shall be dealing with these terms. But to understand Negotiable Instrument Act, you must know presentment for acceptance, presentment for payment. A negotiable instrument may be dishonored either for non-acceptance or for non-payment. Then what is, dishonor of a negotiable instrument? What do you mean by notice of dishonor? And then when that is required to be noted, and then we get a certificate from the notary public, which is known as a protest, with which we shall be dealing during course of our lecture. When we start right from section 99 onwards, you will come across. But this is what is reasonable time for all these things or all these situations. We will have reference to this, but it clearly says, regard shall be had to the nature of the instrument and the usual course of dealing with respect to similar instruments, and in calculating such time, public holiday shall be excluded. I hope you remember the reference to public holiday we had at the time of discussing maturity of a negotiable instrument, and there we had dealt with section 25. A holiday that is declared to be public holiday by notification by the central government in the official gazette is a public holiday. And hence, whenever you want to calculate calculate such time, what is required? Public holiday shall be excluded. Now, this is not the time, we will come to the aspect as to what is this presentment for acceptance, what is this presentment for payment, and all these details with which we shall be dealing as far as the procedural aspect is concerned. But then today, just I wanted to introduce these terms to you, not from the point of view of knowing the meaning of it, because that is, unless I tell you the procedure, it may not be possible for you to understand the term, but with which we shall be dealing during course of our lecture. Section 106, reasonable time of giving notice of dishonor. And it says, if the holder and the party to whom notice of dishonor is given carry on business or live, as the case may be, in different places. Such notice is given within a reasonable time if it is dispatched by the next post or on the day next after the day of dishonor. So this is in case of notice of dishonor which is required to be given unless it is dispensed with as far as section 98 of the Negotiable Instrument Act is concerned, with which we shall be dealing. Yes, very correct, we shall be dealing with this. But then what is reasonable time of giving notice of dishonor? And hence it says, if the holder and the party to whom notice of dishonor is given carry on business or leave as the case may be in different places, such notice is given within a reasonable time if it is dispatched by the next post or on the day next after the day of dishonor. Further part of the section says, if the said parties carry on business or live in the same place, such notice is given within a reasonable time if it is dispatched in time to reach the destination on the day next after the day of dishonor. So that is made clear as far as a reasonable time of giving notice of dishonor. And then 107, last section as far as this chapter is concerned, deals with reasonable time for transmitting such notice. A notice is required to be transmitted to the prior party from whom he wants to recover the amount, and unless that is done by him, he has got when notice of dishonor is not dispensed with, then unless the notice is given by the to the prior party, it is not possible for him to recover amount from the prior party. Hence their notice is required to be transmitted. And hence, what is the reasonable time for transmitting such a notice? And it says, a party receiving a notice of dishonor who seeks to enforce the right against a prior party transmits the notice within a reasonable time. If he transmits it within the same time after its receipt as he would have had to give notice if he had been the holder. So that is the period of time, the reasonable time for transmitting such notice is made mention as far as section 107 is concerned. We may have passing reference to this chapter during the course of time, but I thought as a student of law, the concept of reasonable time should be very clear. If no time is stipulated, everything is required to be done in a reasonable time, and hence what is reasonable time, with which this chapter 8, right from section 105 up to 107 of the Negotiable Instrument Act deal with the same. So whenever this is required to be done in reasonable time, what is reasonable time? For which you have to refer to this particular chapter. With this now, we had dealt with the concept of holder and holder in due course, and what are the rights and privileges as far as holder in due course is concerned. So section 9 over, we have to deal with section 10, payment in due course, but that is a concept with which we shall be dealing as far as the procedural aspect is concerned, that a promissory, in case of a promissory note is required to be presented for the purpose of payment, as in a case the object or the purpose of the Negotiable Instrument Act, with which now you must have mastered it. A draws a promissory note in favor of Mr. B. A draws a bill of exchange in favor of Mr. B, or A draws a check in favor of Mr. B. What is the purpose? The purpose is to carry out the payment. He wants to pay the amount for which the promissory note or bill of exchange or the check is drawn. But who is the party who is supposed to carry out payment? And in case of a promissory note, it is the maker who is supposed to carry out payment with respect to the promissory note. In case of bill of exchange, if you remember the definition of the bill of exchange with which you are dealt, in case of bill of exchange, drawer gives direction to the drawee. So it is an order given by the drawer to the drawee to carry out payment. So it is the drawee who is supposed to carry out payment with respect to the same. But then it's not that, there is some procedure which is required to follow. Drawee is not liable unless he has accepted the bill of exchange. And once drawee accepts the bill of exchange, drawee is what is known as acceptor of the bill of exchange. And the liability of the drawee starts only when he has accepted the bill of exchange, otherwise not. Now, provision regarding presentment for acceptance with which we shall be dealing. Under certain circumstances, when presentment is dispensed with, for which we will refer to section 76 of the negotiable. These are the chapter to which I will make mention after some time. But this is, what is required to be done. Otherwise, a bill so who is supposed to carry out payment as far as the bill of exchange is concerned? It is the acceptor. And who is an acceptor? Drawee. When he has accepted the bill of exchange, he is not labeled as a drawee, but he is known as an acceptor. In case of check, what is required to be done? But definition of the check, if you have not forgotten the part with which you have already dealt, half of the part with which we shall be dealing during course of time. But then what is check? Check is a bill of exchange drawn on a specified banker. So in case of a check, it is a direction given by A to the banker on whom the check is drawn. So drawee is always a banker in case of check. And then the payment of the check. What is the manner in which a payment of the check is required to be carried out by the banker, with which we shall be dealing when we take into consideration different types of checks. For example, the check may be bearer check may be ordered check. Sometimes, the words and company or not negotiable or name of the bank is written between two parallel transverse lines, or sometimes it is also mentioned account payee only. So how he can get payment will depend upon the nature of the check. Yes, but he is entitled to get the payment. A draws a check in favor of Mr. B. B has to go to the bank, and once he has gone to the bank, he will get the payment with respect to the check. Now, how he can get payment with which we shall be dealing as far as the procedural aspect is concerned during course of our lecture. And hence now he is supposed to get payment with respect to the same. And then what do you mean by payment in due course? As we will deal with the presentment for payment and rest of the provisions as far as this enactment is concerned, we will try to understand what do you mean by this payment in due course as it is defined by section 10 of the Negotiable Instrument Act. So today we are not discussing section 10 of the Negotiable Instrument Act, which deals with what do you mean by payment in due course. But then section 11 inland instrument with which we already dealt. Foreign instrument, section 12 with which you are dealt. We have also started with our lecture by having reference to section 13 of the Negotiable Instrument Act, which says negotiable instrument means a promissory note, bill of exchange or check payable either to order or to bearer, with which we shall be dealing. Namely, there are three explanations to this, and subclause 2 with which we shall be dealing when we deal with procedural aspect. Now, with this now, I want to make this very clear. What do you expect Mr. B to do? Who is B? When promissory note is drawn in favor of Mr. B, B is known as payee of the promissory note. When a bill of exchange is drawn in favor of Mr. B, B is known as payee of the bill of exchange. Or when A has drawn a check in favor of Mr. B, B is known as payee of the check. So he can, all these parties, payee in case of a promissory note, payee in case of a bill of exchange, or payee in case of a check, are entitled to get payment with respect to the check, no doubt about it. But that is one right out of two rights. Now, why a negotiable instrument is drawn by A in favor of Mr. B? Because he wants to pay money. And he draws a negotiable instrument because he doesn't want to deal with cash transactions. That is a purpose that is served. So instead of transferring cash from one hand to another hand, you draw a promissory note and B is entitled to get the amount for which the promissory note is drawn. Subject to, of course, the concept, don't forget the concept, namely holder and holder in due course, with which you have already dealt in detail. But along with this, because of the fact that it is a negotiable instrument, he has got right to negotiate it. So what he can do? Mr. B can put that negotiable instrument into circulation to the person to whom he wants to pay that amount. So Mr. B is not interested in the amount, in the sense he is not interested to get the amount. So he won't approach the maker of the promissory note, he won't approach the acceptor of the bill of exchange, or he won't go to the bank to deposit the check in the bank. No. What he will do? Mr. B, when he wants to pay that amount to Mr. D, he will circulate, he will transfer, he will pass on that promissory note, bill of exchange or check to Mr. D. And this process of circulation, this process of transfer is exactly we understand when we read section 14 of the Negotiable Instrument Act. And it defines negotiation. It says, when a promissory note, bill of exchange or check is transferred to any person, so it is transferred to any person, so as to constitute the person the holder thereof. So he transfer it to any person so as to constitute that person. So when B transfers it to D, maybe promissory note, bill of exchange or check, to constitute Mr. D holder thereof, the instrument is said to be negotiated. So when the instrument is said to be negotiated, when B transfers that negotiable instrument to Mr. D, so that he constitutes Mr. D the holder thereof. And if, just to refresh your memory, who is holder? The holder of a promissory note, bill of exchange or check means any person entitled in his own name to the possession thereof and to receive or recover the amount due thereon from the parties thereto. So he is a holder. So what is his right? What is the right of Mr. D? D has got right to claim the amount for which the negotiable instrument is drawn. Now when it becomes mature, of course, the amount can be claimed by Mr. D, or D is entitled to get the amount only when the negotiable instrument becomes mature. And as far as the maturity of a negotiable, when it becomes mature, when it falls due, I mean, we had reference to it at the time of discussing holder in due course, because a person can become a holder in due course provided he has received the negotiable instrument before maturity. Yes. So what Mr. D can do now? Mr. D has got right to get the amount for which the negotiable instrument is drawn when it becomes mature. But being a negotiable instrument, there can be further negotiation, transfer on the part of Mr. D. If D is not interested to get the money, but he wanted to pay money to Mr. E, what he will do? Without following the procedure of going to the person who is supposed to carry out payment with respect to the Negotiable Instrument Act, getting payment and then going to Mr. E, what he can do? He can negotiate, namely transfer that promissory note bill of exchange to Mr. E. Thus, a negotiable instrument can remain into circulation. So it will go to, so now it is Mr. E. From E, he can pass it on to Mr. F, F to Mr. G, G to Mr. H. There is no restriction as far as the number of the persons through whose hand a negotiable instrument can be negotiated, transferred or circulated is the aspect of which you have to take note. Ultimately, yes, who is supposed to carry out payment will depend upon the nature of the negotiable instrument, namely whether it is a promissory note. In case of promissory note, it is the maker. In case of bill of exchange, liability of the drawer starts only when it is dishonored either for non-acceptance or for non-payment by the drawee, otherwise not. In case of a check, if it is dishonored by the banker, then the payee or the holder has got right to proceed against the drawer. This is the contractual relationship with which we shall be dealing during course of time. But today I am trying to tell you, give you general idea, so it becomes so you will understand the purpose or the object which I had introduced to you, no doubt about it. But now we are working out details of the same. So this is exactly what do you mean by negotiation of a negotiable instrument as defined by section 14 of the Negotiable Instrument Act. With this now, during course of time, when we start dealing with the provisions as far as negotiation is concerned, we shall refer to chapter 4, which starts right from section 46. And then how this negotiation will take place. For that, if you read section 46, it says the making, acceptance or endorsement of a promissory note, bill of exchange or check is completed by delivery, actual or constructive. So there must be delivery, and if you classify it into different parts, last but one part says a promissory note, bill of exchange or check payable to bearer is negotiated by delivery thereof. So whenever you want to negotiate promissory note, bill of exchange or check which is payable to bearer is negotiable by delivery thereof. But a promissory note, bill of exchange or check payable to order is negotiable by the holder by endorsement and delivery thereof. This is the time where we will take into consideration. So it depends upon how one can put negotiable instrument in circulation, or it can be negotiated whether it is a bearer instrument. If it is a bearer instrument, it can be negotiated by mere delivery. If it is an order instrument, then there must be an endorsement. And secondly, along with the endorsement, it's not only endorsement that serves the purpose, but then along with the endorsement, there must be delivery of the same. And hence, this is the time for us to know as to provisions regarding endorsement. And in order to understand provisions regarding endorsement, first section to which I will have to draw your attention, 15,
the Negotiable Instrument Act. And what do you mean by endorsement? If it is order instrument, maybe promissory note, bill of exchange or check, what B has to do? B will have to put his signature on the back of the instrument. Back of the negotiable instrument is treated as a part of the negotiable instrument. So Mr. B will put his signature on the back of the instrument, and then that will be, so this is putting signature on the back of the instrument is what is known as endorsement on the part of Mr. B, and then B will hand it over to Mr. D. There will be delivery on the part of Mr. B to Mr. D. And if it is order instrument, we say. If it is bearer instrument, no endorsement is required. Bearer instrument can be negotiated by mere delivery, but or in case of an order instrument, there must be an endorsement and delivery of the same. So when you and mere signature also constitutes valid endorsement, yes. But then, in order to know what is written above the signature by Mr. B, we shall be discussing various kinds of endorsement. So what is written? Whether anybody's name is written, whether anybody's name is not written, whether some condition has been imposed, whether there is restriction as far as the transferability is concerned, whether he writes down that I endorse it without recourse to me. So it all, or if the part of the payment is already carried out, he can write down for the rest of the amount that remains unpaid. So there are various kinds of endorsement in full, endorsement in blank, conditional endorsement, partial endorsement, restrictive endorsement, and sans recourse endorsement, without recourse to me, are the rest of the endorsement with which we shall be dealing when we deal with the rest of the part as far as the Negotiable Instrument Act is concerned. But this has got to understand the meaning of it. We will have to we will start discussing section 15 of the Negotiable Instrument Act. And then the order of endorsement, that is, there can be a first endorsement may be on the part of B, second endorsement may be on the part of D, third endorsement may be on the part of the E accordingly, and rest of the part with which we shall be dealing, no doubt about it, as far as our next part of our lecture is concerned. But this is also the time for me to draw your attention that you must refresh your memory regarding the general principles of the contract, because who are parties as far as the negotiable instrument is concerned? Who can be a maker? Can minor be a maker? What is the competency of the party? Anybody who is competent to contract can be a party to a negotiable instrument. And then what is position as far as what is the position as far as agent is concerned, corporation is concerned, legal representative is concerned, with which and rest of the part, that is one part we shall start discussing right from 26 up to section 29 of the third chapter, which deals with parties. And as soon as we come to know parties with respect to the negotiable instrument, we will start discussing liabilities of the parties with respect to the negotiable instrument. But this part and rest of the part with which we will continue our discussion during course of time as we continue with the understanding of the provisions of the Negotiable Instrument Act of 1881.